It looks like we have started. It is 5:04, and this is the Colorado Oil and Gas Conservation Commission. This is our bi-weekly meeting. It's December 15th, and we will start with roll call.
Yes, Mr. Chair. Commissioner Bowe? Here. Commissioner Gonzalez?
Here.
Commissioner McGowan?
Here.
Commissioner Mesner?
Here.
Commissioner Nanjapa?
Here.
Commissioner Hackett?
Here.
Commissioner Robbins?
Here.
You have 7 out of 7 commissioners present.
Thank you, Hearings Manager Amaro. We appreciate that. Welcome, everybody. Good to see you again. To our participants, we are holding this meeting during evening hours to, we thought, allow folks an opportunity that couldn't speak during the day to be able to come before us, but we don't have very many people that have signed up, which is fine. We do have a short agenda before us. The first matter on our agenda is the consent agenda. Have folks reviewed the consent agenda? Do anyone have questions regarding the consent agenda? Seeing no questions, I would look for a motion to approve the consent agenda.
So moved.
And a second. We have a motion and a second. Is there any further discussion? All those in favor of the consent agenda signify by saying aye.
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 Any opposed? Consent agenda passes. Director Murphy, you're up. Report from the director.
Chair Robbins, thank you very much. Commissioners, it's great to see you again. I have missed seeing you on a daily basis, though I have not missed spending 8 hours a day in a hearing. And to all of Colorado who's listening in, thanks for joining us. I will be fairly brief in my remarks. In the last few weeks, staff has been really entirely focused on making sure our day-to-day operations continue and that we are in the process of preparing guidance for the new rules that were adopted by you all on November 23rd. To that end, we did have a pretty long conversation this morning with in an operators meeting about what the next few weeks look like, and I think that's the right probably topic to cover this evening with all of you. And what we are really primarily focused on when we come to the permitting side of the Colorado Oil and Gas Conservation Commission is making sure that we're continuing to review and take action on appropriate permits between now and January 14th, recognizing that a new permitting regime begins on January 15th. To that end, our staff is also working very hard on finalizing forms. We are mostly through the form development process, setting aside that our IT development side is still working, but our kind of like subject matter experts guiding what the form should say is pretty well done. For the twos, the Form 2, the well permits, the 2A, the 2B, and the 2C, the related OGDP and surface-related permitting documents, and then the Form 9 and a number of other forms that we'll be revising to comply with the adopted rules. We are also working on checklists and instructions for all of those forms. Again, our priorities right now are on the permitting related and transfer of operator related forms and spills and releases. And what we will be finalizing in the remaining few weeks of this calendar year are guidance documents related to permitting decisions so that all of our stakeholders can understand what it is that we're expecting. I also recognize that this is going to be an iterative process. It's the first time our agency has launched 5 brand new forms at the same time. And so we need to be prepared to be nimble, to use the chair's word from so much of the rulemaking process, as we put out guidance and receive feedback, recognizing that one, it will be a draft. It is going to evolve as we learn more about the permitting process and as our stakeholders work through the process. So to that end, we are also setting up frequent meetings with operators to help understand with them and through them how the forms are working, where the busts are, and provide again that feedback and the information that we need to help refine and move forward. So again, we're really, really focused on implementing the rules and really focusing on the permitting side because of the big changes. As we look to some of the other directives from the commission that relates to the new rules. We'll be slowly rolling other guidance documents out and technical work groups through the spring. Again, staff has been pretty entirely focused on a single issue. And now that I've said that 55 times tonight, you'll understand that that's all I've been doing for a few days, given the importance of that work to the state of Colorado. So with that, I'm happy to take questions about what else is going on. We had a great town hall with the Department of Natural Resources today. Thanks Commissioner Bogue and Executive Director Gibbs for providing that insight and leadership. And with that, again, happy to take questions.
Thank you, Director Murphy. I would just note for the record, I think several of us attended the operator meeting today, and I came away thoroughly impressed with the breadth and depth of the work that you guys are doing. And once again, felt like staff is doing yeoman's work there. Loved the delegation to subject matter experts for the various pieces. It's really a great use of the breadth and depth of our expertise there at the commission. I thought we had a lot of good questions from our stakeholders, but again, I just can't imagine the behind the scenes flurry that's happening after all the other stuff that's happening. So great work there from my perspective. Do commissioners have questions, thoughts, comments for Director Murphy?
Just a comment, Chair Robbins. I'll echo what you said. I was impressed by the content as it was presented, and I thought that all the members of staff did a really bang-up job explaining what their next steps were, getting through a huge amount of information on a first pass. So just listening to it for the plan going forward, I think you guys are on the right track and are doing a good job. So I appreciate that.
Great, a lot of nodding of heads. Great job, Director Murphy, as always. At this point, the next agenda item is a staff presentation on the COGCC enforcement process. So if we could bring Jeremy Farron to the house. Magic, there he is.
Okay, can you all hear me?
We can hear you, Mr. Farron.
Okay, let me attempt to share my PowerPoint. Yeah, Angelica, I'm not seeing an option to share my screen.
Go ahead and try again, Mr. Farron.
Yeah, still nothing. Yeah, where should I be looking? Is it just one of the little
It should be at the bottom.
Ah, there we go.
Okay.
Okay, can you all see that?
We can.
Okay. Good evening, Commission. My name is Jeremy Farron. I'm the Enforcement Supervisor. I'm going to run through a quick enforcement orientation. This is actually the same slide deck you saw back in the summer with some updates and some changes. I think hopefully you guys are not drinking from the fire hose as much as you were before, so maybe this is going to be more helpful than it was the first time. But please stop me throughout if you have any questions, anything you want to talk about. Just a quick overview. We'll do a little introduction, walk through the process kind of generally, the penalty calculation, which is sometimes the stickiest part. And then in response to a question from the last hearing, we'll have a discussion of pattern of violations. Like I said, please interrupt throughout. I said this last time, but you know, if you remember nothing else and you've got an enforcement question, the enforcement policy is a really good place to find that information. So it's regulation, enforcement, and it lives right there. So again, the unit, it's myself. We have 3 enforcement officers, and we have a single person working on crafting NOAVs. That's Trent. I should say that, you know, everybody at the agency does some small piece of enforcement, but these are the folks at the agency that do only enforcement, full-time enforcement. Everybody has a little piece of enforcement. We get a lot of help from the AG's office, so 2 assistant AGs. I think you probably met Scott and Caitlin at this point. So these are updated numbers for 2020. We can initiate an enforcement action through a warning letter, an inspection report, or sorry, enforcement generally through a warning letter or an inspection report. These are the numbers. I think it's pretty impressive that we, even through COVID, we've still gotten 22,000 inspections this year, and a decent number of warning letters. The other approach we can take to an enforcement issue is to go straight to an NOAV, and we've issued a fair number of those this year as well. So the informal route, the warning letter, inspection report process, it's going to identify a compliance issue, give an operator a deadline, and if it's corrected, you'll never hear about it. It's never going to show up in front of the commission. If it's not corrected, we can issue an NOAV, and if we issue an NOAV, we're going to seek a penalty. NOAVs, that's formal enforcement is the sort of jargon we use. And there's a lot that goes on behind the scenes that you folks don't see. It's in your portfolio, but you're not going to see all these documents as they come in. But an operator is going to file an answer. Staff is going to file an application to have a hearing in front of the hearings unit. An impartial hearing officer is going to be assigned. They're going to act like the judge. There's going to be a notice and a lot of pre-hearing process, but really we're going to just start a settlement negotiation because most of these matters end in settlement. This settlement document is an AOC. You've seen a lot of those at this point, so I won't belabor that point. But I will say, they're subject to hearing officer approval, and they take sort of an independent, third-party review of those documents. So it's a good check on what we've done to make sure we haven't strayed from, the policy or rules. And then it's obviously transmitted to you guys to take a look at. The flip side, if we can't settle, it's going to be an OFV hearing. That's exceedingly rare. Hasn't happened in a few years. There might be a few on the horizon. We'll see. But that's a formal hearing in front of a hearing officer with exhibits and witnesses and the whole 9 yards. But the order is going to look kind of like an AOC. It's going to have compliance requirements and a penalty. These are updated numbers for 2020. I have to do an annual report, so we just put out our annual report. We had 33 enforcement orders this year, 27 AOCs and 6 OFVs. Those were stipulated OFVs, so it's a little different. We didn't actually go the full-blown hearing route, but the operators agreed to what we were suggesting. Some other information here. Our total penalties this year obviously were skewed because of the Firestone AOC and that tragedy, but pretty decent numbers this year, even considering COVID and working through remote means. So to jump on penalty calculation, again, this is kind of the stickiest part of most NOAVs. NOAV's been issued, rules are listed in that NOAV, and then an enforcement officer or an AG is going to be assigned, and they've got the right to consolidate some violations or dismiss them if they're just on a factual basis, and that happens fairly often. But then we just go through the nuts and bolts, and I'll go pretty fast because we did this last time, but you got to count the number of days. By rule, we have to impose a penalty for each day. And so there's a lot of work into counting those days, a lot of negotiation with the other side, and a lot of coordinating with staff. We're going to look to the rule to figure out what class it is that's established in the policy. We're actually working through classifying some of the rules that you all just adopted. Step 3, working on, what was the impact of this? That's a lot of collaboration with staff trying to figure out, was it just a paperwork issue, so there really wasn't an impact in the real world, or was it, something that spilled and actually created an impact? And you get, a presumptive daily penalty, which is just established in the rule. This is that portion of the rule that establishes those presumptive daily penalties. And for, all of our orders, we try to put this table in there. So if you're curious about how we got to a penalty calculation, I know when I have a question, this is the table I flip to because it tells me what we've done. This is from a real order. And so, if you're curious about a penalty, that's the place to go. So for shorter duration penalties, it's just straight math, the number of days times the daily amount. For longer duration, we make use of the duration matrix. And really, I think I probably said this last time, it's just a decline curve. So if it's a longer duration penalty, and longer duration means anything longer than 10 days, the daily penalty just declines over time so that we don't have, ridiculous penalty amounts being imposed. So for instance, in the example, this order here, it was longer than 10 days, it was 24 days. And so we end up, if we use the duration matrix, we end up with a more appropriate penalty size. This is what it looks like in the policy. We have a spreadsheet that does the math. And most of the time we get that right, but occasionally we've been known to mix up something. But yeah, it's just a decline curve that decreases the daily amount. We started putting these little asterisks in the penalty tables just to explain that in fact we've used the duration matrix there. We have always explained it in the text below the table, but we started putting it straight in there because if you're only looking at the table, you might question how we got to that number. Next step is to decide whether there's any aggravating or mitigating circumstances. Those are pretty rare, both aggravating and mitigating circumstances. To the question about pattern of violation, I would note number 7, pattern of violation is one of the aggravating factors. It can result in an increased penalty. We're still capped by the statutory maximum, but we're no longer really bound by that sort of standard daily penalty if we think there's an aggravating factor. Same for mitigating factors. I think you might have seen a few in your time on the commission where it's a percentage off of the total penalty because of something that the operator did that we want to encourage. There's some additional considerations in penalty calculation. Those settlement discounts, operators' ability to pay, and suspended penalties. We use those tools pretty regularly. And the goal is really just to impose a penalty that's appropriate to the nature of the violation within the parameters that we have to work with. And so if I'll just jump into pattern of violation, which was a question from last year. So pattern of violation, that concept, it appears in the Act. There's not much more than just that phrase in the Act. It doesn't really, put any meat on the bones, except it says, that if we believe there's a pattern of violation or this other category, gross negligence or knowing and willful misconduct, we should pursue an NOAV, a hearing, an order. There should be some consequence if those factors exist. And so that's what the Act says. The current Rule 523, it's going to be future Rule 525, says the same thing, really, that we need to issue an NOAV if we believe there is a pattern of violation or, again, that other category. But this rule, which didn't change, I don't think you guys made any changes to this 525, so this version is going to be the same in future rules. The real meat are these other two subparts, so subpart 2 and subpart 3, because, and I've highlighted, subpart 2 gives us some additional remedies, and one of which is to suspend an operator certificate of clearance or withhold new permits, or both. And so the certificate of clearance, if you're not aware, that's the authorization for product to be removed from the location. And so if we suspend somebody's certificate of clearance, their gas can't leave the location, their oil can't leave the location. So really what you're doing is cutting off a revenue stream. And then obviously not granting new permits, that's pretty obvious. But what's interesting is that last sentence in the rule, which is that the suspension is only going to last until the non-compliance is remedied and the penalty is paid. And so I've always thought that a sophisticated operator, most of the time the compliance is either taken care of or it's close. I've always thought that if we went this route and imposed one of these remedies, that an operator would just cut us a check that day and then make sure that the compliance had occurred fairly short order. And then that suspension just kind of disappears. And so it's a pretty big hammer. It's two pretty big hammers, but I don't know how long the duration would be practically. I'll sort of cut to the chase here. We've never imposed those two remedies in the time I've been here, which included when this rule was adopted. So they're pretty big remedies, but they have not been used. Subpart 3 has one more piece to it that provides a little flavor here, and that's that when pursuing a pattern of violation, we can't look at mere allegations. We actually have to look at adjudicated orders. And so, you know, a warning letter, an inspection report, that's not good enough. An NOAV is not good enough either. You actually have to end up with an adjudicated order. And so that has, in a couple instances, sort of controlled what we've done as far as an enforcement proceeding. So I went and I looked at the instances of patterns of violation over the last 5 years. There's only been 5. And so the first 2, Petrohunter and Energy Search, those were defunct operators. Those were non-responsive, non-compliant operators. These were orders that terminated their right to operate in the state of Colorado when we claimed their bonds. So in those 2 instances, the pattern of violation resulted in an aggravating factor and an increased penalty, but they didn't pay because it was a non-responsive operator. So it was in the order, but didn't really have much effect. The last 3, including Sandridge, which you saw at the last hearing, those are functional operators, for lack of a better phrase. And so those orders, it was an aggravating factor, it was a penalty multiplier, and it had an impact because there was an increase in the penalty amount. Now they have a pattern of violation on record, and should they, you know, have similar non-compliance in the future, you know, the pattern's already established. So we could go with a larger multiplier. We could, you know, go with one of those other remedies, whatever we thought was appropriate. But that was the 3 instances where we had a pattern of violation against a functional operator. But again, we didn't go the route of those other 2 remedies of suspending certificates or withholding new permits. So just to kind of summarize, you're going to get a larger penalty, and you have the option of suspending certificates or withholding permits, but to date, that hasn't been something that has appeared in an order. You know, I think there might be situations where that makes sense, but so far it hasn't really resulted in use of those 2 remedies. And with that, you know, I'll open up to any questions about patterns of violation or anything else I've talked about.
Great, thank you, Mr. Farron. Questions from commissioners? Commissioner Messner?
Thank you, Mr. Chair, and thank you for the explanation there. That was a good refresher for me. I think the question that I've got is, you know, we've seen a couple of instances, at least since I've been seated as a commissioner, of patterns of violations. And you know, in your experience, as you start to see some of these patterns of violations come into play, do they continue? Or, I mean, once someone's been tagged with a pattern of violation, do you see some of the things that would have initially created that pattern of violation like end? Like, does the situation improve on the ground?
Yeah, so in my experience, you know, with these 3 later orders, Magpie Extraction and Sandridge, you know, staff has not been coming to me and saying, hey, look, we still have this issue, you know, they're still having, so in my experience, it has worked well enough that it hasn't gotten to my level. That's not to say there's not isolated incidents of similar issues out there. But yeah, it has apparently worked, at least for these 3. Again, for the defunct operators, you know, there was no expectation that anything was going to happen. So.
And does that pattern of violation kind of moniker, is there a statute of limitations to that, or does that sit with these operators indefinitely?
Yeah, it's going to sit with them forever. And like I said, if one of these operators had a similar issue, I could point back to that old order, right, and just say, look, this is yet another incident, another pattern. And I would say, you know, whatever the penalty aggravator was previously, you know, let's say it was 20%. I would say, well, now 20% is just not good enough. It needs to be 30% or 40% or something, and say, look, you're not getting the message. What else can you do to sort of get this across? So yeah, there's no statute of limitations. It's going to be an order of the commission forever.
Okay, thanks.
Other commissioners with questions? Jeremy, or Mr. Farron, sorry. It's like after 5, so I apologize.
I take my tie off.
So when was the guidebook that we have here last sort of revisited is one question.
Yeah, so I can actually scroll that page. I think it was 2015 is when we adopted it. It's in need of some changes. It's in need of some updating. We're currently, last revision was 2015.
Okay.
We're currently classifying the new rules that you all adopted. And so that'll be a big revision. But there's some things that could be improved in that policy for sure.
Okay. And that's what I anticipated. And now that we've got this commission that has additional capacity, maybe we amongst ourselves can be involved in that, or one commissioner. Another question that I had, and you may not have the answer to this and you may want to think about it, bring it back, but, you have, this violation, we have rules, and then we have, if you break a rule, then you have to, you're responsible. And we want our guidelines to, be to a certain extent deterrence so that folks don't, comply with our rules. Has the commission taken a thought about that or look into that concept? Like, is what's on the ground right now, is it generally establishing compliance? Or, and I guess kind of a different way of looking at it is non-compliance because the actors are unaware of something, or is it intentional? That's kind of a lot of different loaded questions. I'm just trying to get a sense of what your opinion as in enforcement, how this, how you think this is working, whether it's not, or whether we should look into that as we look into updating the guidance.
I think it's working. There's clearly still work to be done. I will say that we have taken a look at particular rules and made that a focus, and spent a lot of time educating people about that. And as a result, there's been improvements. MITs are a really good example. That was, there were a lot of operators who were delinquent on MITs. And then, when I first started here, that was a focus. So I think that's where we have had the most success, is picking something, focusing on it, providing guidance, providing warnings, trying to educate people. I don't know what the future holds with the new rules. I think it's going to be a lot of opportunity to educate, and if we can focus on certain rules and make those priorities, I think we'll see compliance on those rules pretty quick. But I just don't think the average operator has read all of the rules, and so there's a lot of instances where they're out of compliance because they're just not aware of something. And there are bad actors too who intentionally, don't comply with rules. But I think for the most part, people, try to comply, but sometimes might not just be sophisticated to know all the various requirements. And so I think that's the next step with the new rules, is a lot of education.
Yeah.
But yeah, if we want to focus on a couple areas, I think you can get compliance on those areas pretty quick.
Okay. And I guess that's also where I was segueing into is, with the new rule regime coming into play on January 15th, there is a education component there. I mean, we saw that this morning at the operator meeting with operators asking questions about, how do you do the forms, and how do you, do this component, and et cetera. So, okay, well, that is yet more that is on everyone's plates, but thank you for those answers to those questions. Are there other questions from commissioners? Great. Oh, Commissioner Messner, please.
Yeah, sorry, I just had one other question. So, I mean, I appreciate that the two further steps beyond the patterns of violation, have rarely or don't get utilized. I mean, but that's still, but are you saying, I mean, I'm just trying to clarify, are you saying they don't get utilized because they're not an effective deterrent, or we just haven't gotten to that point with any of the operators that we felt like it was necessary to utilize those?
I think it's more the latter. We just haven't had a factual situation where we felt like that was an appropriate response, which, there could be future situations. I have a couple situations in mind where, if it doesn't go the right way, that might be an appropriate remedy. So it's not that they, will never fit, they just haven't yet. So.
Okay, thanks.
Commissioner Gonzalez.
Thank you, Mr. Chair. Thank you, Mr. Farron. Do these patterns of violation, do they transfer across operatorship? So if an operator, for instance, Noble or Anadarko selling to a bigger operator like Oxy or Chevron, do those pass along to the new operator, or do they start with a clean slate?
They would start with a clean slate. It's specific to the operator. And if we tried to claim that it passed with the property, I think we'd have a pretty strong response from the subsequent operator saying, it's not me, this was the prior operator, and we'll do better, so give us a chance.
Thank you.
Other questions from commissioners? Great. Thank you, Mr. Farron. We appreciate your presenting to us this evening. With that, we are at commissioner comments amongst ourselves, and we have public comment that's supposed to start at 5:50. I don't think the two people that signed up are not with us yet, so we'll give them until 5:50. So do we have comments amongst ourselves to bide time for 14 minutes? I've got one, and that is, at this point, we do not have slated on our calendar upcoming meetings, either for the rest of this month or how we might want to do start in January. And I don't think that there's a need, Director Murphy, correct me if I'm wrong, for additional meetings this month. We're rolling into the holiday at the end of next week, and then we roll into New Year. I do think slating meetings starting that week of the 4th, I think, does make some sense. My 2 cents on this too are that we should probably meet weekly, at least to start. I know that I, as one commissioner, and I'm sure others, are anxious to start to learn, more about, now that we're past that initial rulemaking, to have work sessions and study sessions, and there's all sorts of topics that I think that we could develop up, and we'll get that to you, Director Murphy. And we want to learn not only from our staff about the things they're doing, but give opportunities for stakeholders to appear before us. So I think weekly does make sense. Commissioners Director Murphy and I did have a discussion offline earlier today, and she prefers if we were to have meetings Wednesdays, and that works just fine with my calendar. So I propose meetings starting January 6th, starting at 9 a.m., and maybe we can do some in the evening as well, but just each Wednesday, and 9 till whenever we need to be done. Does that not work with anybody? Is everybody okay with that proposal? Okay, I'm seeing shaking of heads. So hearings manager Amaro, if you could get that calendar for us, that would be great. A second comment from me to commissioners and to Those that are appearing with us is the Department of Natural Resources, and we met today, and we will continue to be working from home, for the near foreseeable future. So you'll be seeing us via Zoom. We as commissioners, I think, have done a great job of handling COVID-19 and the work from home orders and having these meetings virtually. But just FYI, that's on our agenda for the foreseeable future going into the first quarter of 2021. Other commissioners with comments? Commissioner Hackett.
Sure, I just have a couple goings on from CDPHE to add. I guess the first one, and this goes without saying, but Director Murphy, like you've done in the past, if you just want to share your tentative hearing schedule with me, I'll make sure to run that by our boards and commissions to make sure that everything works. But looking at Wednesdays, I think that should align nicely with the Air Commission's schedule. So I'll be on the lookout for that. The other item, I don't know, Chair Robbins or Director Murphy, if you want me to speak about the Health Effects Institute letter of support, I can provide some more details about that if you'd like. I'm not hearing any no's. So
Mr. Hackett, you've frozen and we can't hear you.
Let me stop my video. Can you hear me now?
I can hear you. I don't see Jeff anymore though.
Yeah, Jeff froze.
Same here. I can hear Sean, and Sean was not frozen on my screen.
So Director Murphy, if it's okay with you, I'll just give a quick highlight about the Health Effects Institute letter. So that was a joint letter where we were seeking support from the Commission, from Department of Natural Resources, as well as CDPHE and the Air Pollution Control Division. There was a proposal that a research team from Colorado State University, Colorado School of Public Health, National Jewish Health, and CDPHE put together. That proposal is entitled Measuring and Modeling Air Pollution and Noise Exposure Near Unconventional Oil and Gas Development. That proposal, we're hopeful that it's going to provide really valuable data that will help inform both the Air Quality Control Commission's and COGCC's ongoing rulemaking efforts, and also help further our missions to protect public health and the environment. If that grant's awarded, after factoring in indirect costs, the research team could get as much as $1.75 million to conduct the study. So just wanted to say we're incredibly thankful for the support of key decision makers in DNR and COGCC for that effort. And we'll make sure to share with you all the results of whether or not we get that grant proposal, and if so, how much, and what that study will look like going forward. If folks don't have any questions about that, the only other item, or a couple more items I wanted to flag this week, is the next Air Quality Control Commission hearing. That'll start on Thursday. And this is more of an FYI for folks who are interested, and there's definitely not an expectation for COGCC commissioners or staff to participate. But if you'd like to, there's a couple things that may be of interest to you. Starting tomorrow at 4:30, there will be a public comment session. But the main item of interest, I think, will occur on Thursday, December 17th. Starting at 8:30 that morning, there'll be a hearing on regulation number 7, or it'll be a request for hearing, where the Air Division will request that the Commission set a hearing in March or April to consider additional requirements for pneumatic controllers that are used in the oil and gas sector. And later in the morning will be an actual rulemaking hearing surrounding the 2008 Ozone State Implementation Plan, or SIP, Colorado's Serious Ozone Non-Attainment Classification, and the regulations associated with that effort. As you are all aware, that's kind of another piece of the puzzle for the Air Commission's mandate to minimize emissions pursuant to Senate Bill 19-181, make progress towards the greenhouse gas emission reduction goals or targets in House Bill 1261, and come into compliance with the National Ambient Air Quality Standards established by the Clean Air Act. The main element of that rulemaking that I think might be of interest is proposed revisions to regulation number 7, which would establish additional emission reduction monitoring, record keeping, and reporting requirements for the oil and gas sector. That the hearing, as well as a Zoom link for that, can be found on the Air Commission's website. And happy to answer any questions for that. But if folks don't have any, I did have one more thing I'd like to kind of advertise for CDPHE, and that's a continuing legal education course that Director of Environmental Programs John Putnam and several others will be putting on January 7th. That training is called Giving Voice to Disproportionately Impacted Communities in front of the Air Quality Control Commission. It's a free training through the Colorado Bar Association that's open to attorneys and non-attorneys. Among other things, it will cover the Air Quality Control Commission rulemaking process, how to request party status, and how to navigate the party requirements. So it would definitely be a pretty informative educational opportunities for commissioners and general members of the public. But importantly, it's much more than that. It's actually a call to action. And really what it is to try and generate interest amongst pro bono attorneys to provide free legal representation to nonprofit organizations and disproportionately impacted communities for the upcoming Regulation 22 hearings that will occur in 2021. And Regulation 22 is the greenhouse gas emissions reduction and reporting rule. So we're really hoping that this might generate some interest for some free legal representation for parties who might not otherwise have a very meaningful seat at the table. So I would encourage you to jump on the Colorado Bar Association website, and you can go ahead and register for that course for free if you'd like, or feel free to reach out to me and I'm happy to share the registration link. And that's all I had.
Thank you, Commissioner Hackett. I'll reach out right now. I'd love to get a copy of that. I would like to attend, and I need CLEs. So that sounds great. It's a double win for me. Questions for Commissioner Hackett from others? Really appreciate the updates. Commissioner Najapa.
Thank you, Mr. Chair. Thank you, Commissioner Hackett. Appreciate that information. What was the date of the Bar Association training that you mentioned? Sorry, I missed it.
It's January 7th, and I just posted a link in the chat.
Okay.
It's like January 7th at 12 o'clock.
Thank you.
Great, thanks. Others with any questions? Other commissioners with comments? All right, seeing no further comments, Hearings Manager Amaro, did either of our participants who signed up attend?
Yes, Mr. Chair, Giselle Hersfeld, she's signed in. She is online. She can, I don't see Kimberly yet. She'd like to raise her hand and let us know she's there.
Hi, can you hear me? This is Giselle.
Yes, we can.
Okay, thank you. My name is Giselle, and I'm speaking today on behalf of 350 Colorado. We in the state of Colorado are experiencing an alarming array of overlapping crises. We have a respiratory health pandemic with 4,027 deaths in the state attributed to COVID. We have an air quality crisis with the American Lung Association giving the Front Range of Colorado an F-grade air quality rating. We have a financial crisis with a looming statewide budget deficit of $3 billion. And we have an environmental crisis with an unprecedented drought season leading to the 3 largest wildfires in Colorado history, all occurring in 2020 alone. This is not just another year in Colorado. This is a state of emergency. And we are supposed to respond to emergencies with swift and bold action. And that is why I'm here today, because I know that living in this state, you have seen what is happening, and I hope you are as terrified as I am of what will happen if we do not dramatically change the direction that we are headed. In a time of respiratory health pandemic, it is irresponsible to continue to approve and allow permits for oil and gas activities, which are responsible for as much as 40% of the pollution that resulted in the EPA reclassifying Colorado air quality as being in serious violation of air quality laws. People with reduced lung capacity, those who are immunosuppressed, and the elderly are already at a heightened risk of negative COVID outcomes. And now more than ever, we must enforce stronger air quality protections. In a time of severe financial crisis and a $3 billion statewide deficit, we should not be approving the expansion of an industry in which 88 companies have already filed bankruptcy this year, with filings totaling $89 billion in debt. Colorado ranks the 5th highest state in the US for the number of bankruptcy filings by the oil and gas industry since 2015. And with bankruptcy comes cut corners in maintenance and cleanup of orphaned wells, the cost of which is likely to fall onto taxpayers if industries cannot cover the costs. In a time of rapidly escalating climate catastrophe, it is more important than ever that we phase out all new fossil fuel development in the state. The oil and gas industry is contributing significantly to the climate crisis through vast methane leaks and oil and gas burning. The Intergovernmental Panel on Climate Change tells us that for a 66% chance of avoiding climate catastrophe by limiting the global average temperature rise no more than 1.5 degrees Celsius above pre-industrial levels, the world must achieve net zero greenhouse gas emissions by 2038. If we intend to leave our children and our children's children a livable and sustainable planet, we have to act now because it is rapidly becoming too late. For the sake of all current and future generations on this planet, I urge a rapid shift away from oil and gas development in our state. I call for all relevant state agencies and divisions to work together to craft and deploy a bold plan for a rapid and just transition away from oil and gas development in Colorado. Thank you so much for hearing me today.
Thank you for taking time out and appearing before us and for those public comments. I believe we have Kimberly Wagner next.
Can you hear me?
We can.
Great. Good evening, commissioners. As 2020 comes to a close, it's important that we acknowledge all the hard work and accomplishments that took place during those mission change rulemaking sessions. But it's equally important to recognize those areas of regulation that have fallen short of the mark to protect Coloradans, our environment, and to achieve Colorado greenhouse gas goals. We need to think ahead to the guidance and the enforcement of the new mission change rules and plan for the new rulemaking in 2021. Including the 2,000-foot setbacks in the 600 series rules was a historic achievement, but it's still not enough. As 350 Colorado presented to the commission, fracking emissions have been proven to negatively affect the health of people at distances far greater than 2,000 feet. Dr. Sandra Steingreiber provided powerful, science-based testimony that fracking isn't safe for humans at any distance. Knowing this, it will be extremely critical for the COGCC to enforce that current 2,000-foot setback mandate when you permit and deny all permits that are exceptions to that rule. Every single day, the greenhouse gas burden placed on our planet is increased by emissions from the Colorado oil and gas industry. Perhaps the most worrisome are the methane leaks that have been underreported due to inaccurate monitoring and industry greenwashing. If we don't slash methane emissions and dramatically reduce carbon emissions, staying below the 1.5 degrees Celsius of global warming that is targeted by the IPCC is impossible. The COGCC must address the role that oil and gas emissions play in creating an enormous gap in what we can currently achieve in GHG reductions, especially methane reductions, and the targets called for in the state GHG roadmap. The 300 series does not meet this monitoring requirements that are necessary to achieve this. Rulemaking on financial assurances from the oil and gas industry won't take place until fall of 2021. Every well that's permitted before tougher standards are put in place that ensure company financial viability and require larger bonding for capping wells will put the state and taxpayers at risk for a whopping $270,000 bill if that well is orphaned. Given the large numbers, as Giselle said, of oil and gas company bankruptcies in the last year alone, this is a financial burden that we can't afford to take on. And when bankruptcy courts seize assets, they don't put the cost of orphaned wells above creditors. Please carefully consider when you issue permits the future, the future financial impact of orphaned wells until stricter rules are enacted. Health risks, environmental risks, financial risks, non-attainment of greenhouse gas emission goals. What more incentive is needed to step up our efforts to put the brakes on fracking and phase out all new drilling permits by 2015? Commissioners, your mission is to protect public health and the environment over oil and gas industry interests, as I know you've been told many times this year already. The price Colorado is paying to support a dying industry is not worth the continued death and destruction that's being wrought by their accumulating emissions. Thank you so much for the opportunity to speak tonight.
Thank you, Ms. Wagner, for taking time out of your evening and appearing before us and providing your testimony. That concludes public comment. Remind members of the public that if you'd like to present to us, we encourage public comment. We ask that you sign up ahead of time so that we can allocate the time appropriately. And we will be meeting, as we mentioned earlier, weekly. I don't know if we'll do public comment every week, but we will make sure that we set aside time to hear from the members of the public on the things that are happening at COGCC. So thank you for your time this evening. Commissioners, at this point, that concludes the matters that were on our agenda. Does anyone have anything further? All right, well, seeing none, we would look for a motion to adjourn and a second.
So moved.
Second.
We have a motion and a second. Before we adjourn, everyone, happy holidays. Thanks for all your good work. Be safe. And with that, all those in favor of adjourning signify by saying aye. Aye.
Aye.
Anybody opposed? Doubt it? Then we're done. Thanks, everybody. Stay safe. Happy holidays.
Happy holidays.